As I said, good morning, everyone, and welcome to this working and very educational meeting on how to use the system of special procedures of the UN in order to protect those who protect rights. The intensity and the resurgence of attacks against human rights defenders make their protection increasingly essential for the effective realization of human rights and the safeguarding of rule of law. Several independent experts appointed by the United Nations, known as special procedures, regularly shed light on these cases through communications or urgent letters addressed directly to states. Despite this opportunity, discussions with the United Nations special procedures working to protect human rights offenders reveal a low number of cases submitted by the African continent and those in the diaspora. We have gathered here today to hear from the Special Rapporteur on Human Rights Defenders, Andrea Bolaños, and their Secretariat on how to use the mandate of the UN Special Procedures to defend those who defend rights. This webinar is organized by the Network of Legal Professionals for the Protection of Human Rights, of the Human Rights of Human Rights Defenders in Africa, NLPHRD, in partnership with the International Service for Human Rights, ISHR, and the UN Anti-Racism Coalition, or UNARC, with a special thanks to Gelades for making interpretation a possibility. Angelica will talk to us today. She will explain what are special procedures. I think somebody asked that on the chat, so she will talk about what are special procedures and how they can help human rights defenders. She will also explain their communications procedure, what are the types of communications that exist, and she will share tips to help us make our submissions more effective. So Angelica, the floor is yours.
Thank you so much, Lamar. I'll try to share my screen and I hope it works well and you can hear me well. And in case I have problems with my connection, I may ask for your assistance kindly. So thank you, everyone. It's great to be here and talk to you about the work of special procedures and how to submit information. Today, I'm going to guide you a bit through indeed what special procedures are and what are the tools at their disposal and the scope of their work, and how to submit information to special rapporteurs through the OSHR office in Geneva that supports the mandate of Andrea, but also we have other colleagues supporting the mandate of other special procedures experts. And I'm going to touch upon also a bit about on the issue of protection of human rights defenders and discuss the tools also in light of this and what we contribute to that and how we contribute to that and what we can do in that regard. So the special procedures of the Human Rights Council, as you know, are there to promote and protect human rights and prevent human rights violations. They are appointed by the Human Rights Council, and it's important to highlight that the experts belonging to the special procedure system are independent human rights experts. They are unpaid and they're acting in their personal capacity. They do not represent any government organization. They are not part of UN staff, but they're supported by a team within the UN. Here, there's me and Sarah, my colleague, also is present today. And every special rapporteur, independent expert, and working group has their own small team that supports them within OACHR, but they still act independently. And it's important to highlight also this independent status of mandate holders because this is what ensures the impartiality of their assessments and analysis. The term is limited to maximum 6 years, so normally they are appointed by the Human Rights Council for a term of 3 years, and then the mandate can be renewed for another 3 years, up to 6. As I was saying, there are different mandate holders. There are special rapporteurs such as Andrea, special rapporteur on human rights defenders. There are independent experts, for example, independent expert on SOGI, sexual orientation and gender identity rights. There are also working groups that are a group of five experts, and they act also in similar ways as special rapporteur and independent experts. They have their own separate mechanisms, but the working methods when it comes to communications, submissions, and public advocacy are very similar. And I'm going to explain to you a bit later what are these tools. There are 46 thematic mandates and 12 country mandates. I think you know more or less. I mean, it's easy to figure out what the distinction is, and there are teams at the OSHR also supporting both thematic and country mandates. I've not listed all of them here, but you can find all the mandates on the OSHR website. There are some on civil and political rights, on economic, social, and cultural rights, on minority groups, and so on and so forth. So it's very broad coverage. And as for the country mandates, those are the countries where the Human Rights Council has identified particular human rights violations that require an independent expert to report and investigate on that. When it comes to the scope of the work, the tools at the disposal of special rapporteurs, independent experts, and working groups go from thematic work through reports, but also other type of documents produced to country visits, communications, awareness raising, and technical cooperation. And I will go through these tools one by one. But first, maybe I will ask you to, if you oh, sorry, I'm just. Yes, first maybe I will go to talk about. I'm going to talk about the special rapporteur on human rights defenders specifically, as this is the mandate we cover. But as I said, this applies to all special procedures. So when we talk about the tools per se, and I'm gonna also highlight how we work together with other teams supporting other special rapporteurs and experts. What I'm saying about the special rapporteur on HRDs applies in terms of working methods, applies also to other special procedures. Andrea is appointed to promote the UN Declaration on Human Rights Defenders, to study trends and challenges related to the right to defend human rights, make a recommendation to states through, in various ways, report, raising concern through communications, as we said, and also all the tools at our disposal contribute to the study of trends and challenges and the formulation of recommendations. And Andrea asks to respond to information that she receives from defenders on the ground. So this is also to highlight how important it is for you to submit information to the mandate, as we can only act if we receive information from you. Part of the mandate is also to adopt the gender perspective, and as Andrea was highlighting in her talking points, she will also adopt a more strengthen the intersectional approach when it comes to the protection of human rights defenders, the analysis of the challenges they face, and considering the needs and also the specific layer challenges that result from belonging to different groups of people, and also the work that they do. So maybe before we start, indeed, I wanted to ask if you can tell me briefly what you think the special rapporteur can do in this scenario. Let's say human rights defender has been arbitrarily detained, received the threats, and needs emergency relocation funding. Which responses do you think are the correct ones? There can be one, there can be more. And I'm going to read the responses, and you can maybe type in the chat which ones you think are correct, and I can then comment on all of them. So the A, secure immediate release from detention. B, send a communication to the government. C, provide relocation funding. Or D, raise the case publicly and through advocacy.
So we see a lot of bees.
Very interesting. Yes, indeed. The special rapporteur can send a communication to the government. This is indeed the main tool, the one of the main tools that she has at her disposal. So that's correct. When it comes to C, provide relocation funding. Unfortunately, the UN and special procedures do not provide funding. So this is a kind of support that the UN cannot give. And we're gonna talk more about this later on in the presentation. Raise the case publicly and through advocacy. This is correct. There are ways not only through communications to governments directly, but the cases can also be raised publicly, and there are different criteria according to which usually the special rapporteurs choose how to react. It's upon their discretion, of course, but there are some generic criteria that are followed. And it's interesting also, I think nobody or very few said in terms of securing immediate release from detention. Of course, this is then up to the government. The special rapporteurs cannot secure a release. They can advocate for a release, and their actions can contribute to a release, but they cannot ensure, they cannot promise that the person concerned will be released. This is more or less what we said. There are communications, and we're going to see different types of communications. There are 2 reports per year. Now, one to the Human Rights Council and one to the GA per year, to the General Assembly. But the one to the General Assembly now, it will be only 2 for every 3 years, for every mandate. So there will be a report to the General Assembly, for example, this year, not next year, but the year after, there will be another one. Fact-finding missions, this can be done once a year. It used to be 2 missions per year, but now it's only 1. And also the special rapporteur can meet with human rights defenders during events, consultations, hearings. There are different ways through which the special rapporteur can talk and engage with human rights defenders, both online and offline. And when it comes to public engagement, the most rapid tool is social media, and also often it's the quickest, but also the most used tools. But there are also PRs and public statements that are possible on cases on which there was previous engagement. So going back to what the special rapporteur cannot do, she does not act on cases of human rights defenders that are not affected or at risk, meaning that there should be issues where human rights defenders are facing risks. There are also analyses, of course, of the broader trends and good practices, but when it comes to individual cases, we analyze, we take up cases when it comes to also we assess the level of risk. And she cannot provide funding, and she cannot provide relocation support, for example, or protection on the ground. And I'm going to come back to this at the end of the presentation. The first tool at the disposal of the special rapporteur is indeed annual reports. I was mentioning earlier that the reports are 2 per year on different themes and topics, and normally these are understudied issues or about priorities, and they help to renew action and recommendations and highlight certain specific issues that affect human rights defenders, but also other special procedures may have will have reports on their own thematic issues or country-specific issues that they work on. The focus can be different about different teams, but what the special rapporteurs does of human rights defenders specifically, the report to the Human Rights Council is in March, so every year in March, while the report to the General Assembly is in October. And as I was saying, there will be a report about Andrea's priorities to be presented to the General Assembly in October, and the next one to the Human Rights Council, for which we have the call for input out. And you can find find a link in this presentation. I think we can circulate the presentation afterwards. If the organizers can circulate it, that would be great. Otherwise, we can copy paste the link in the chat as well. And it will be about the topic of mental health and psychosocial well-being of human rights defenders, as Andrea was also mentioning in her speech. So there is usually a call for input for all the reports that are presented to the Human Rights Council and to the General Assembly, and they are published several months before the reports are out. So I invite you to keep an eye on the website of the OSCHR, because also different experts have different reporting periods. So, for example, as I was saying, Andrea reports to the Human Rights Council in March, but other experts report to Human Rights Council in June and in September. So, it really depends on when they report and when they need to submit the report. And so these call for inputs are really on a rolling basis, on a rotating basis. So I advise you really to check the website, but also to follow the social media channels of special rapporteurs and other experts. When it comes to country visits, as you know, there are several states, many states that have standing invitations. However, even if they have standing invitations, it's unfortunately not possible to just go and do an assessment visit to the country on an official basis. It takes a long time often to negotiate with the states, and the special rapporteur needs a specific invitation or a response to a request to visit to be able to access the country, cooperate with the government. The government will then facilitate meetings from the government side, while usually the way it happens is that the special rapporteur arranges the meetings with civil society herself. So these are separate processes, but the government facilitates the visit in a way that you agree on the dates, and then they facilitate the meetings with government counterparts. The report of the mission is published normally several months after the mission has taken place, and is also presented to the Human Rights Council. So the next visit that the Special Rapporteur on Human Rights Defender has is to the Marshall Islands, actually in a bit more than a month. And this report about the country visit will be presented to the Human Rights Council in March 27, just for you to have an idea. And there is also a call for input open. I don't know if it can be of interest to any of you, but there is also a call for input on the website for this visit. It can be very hard, as I was saying, to confirm country visits. Now we can do one per year. Before it was two, but also many states are a bit. It takes time to confirm whether they want the visit of certain mandates and not others. Sometimes they accept maybe less controversial issues in their eyes, or maybe those aligning more with the approach to multilateral affairs. So I think it's also a matter of negotiating and approaching strategically different countries, but we see that it's not so easy to get invitations, unfortunately. And you can check also on the website which visits were requested. For example, here I put a couple of examples. You can find these on the website at the link provided. You see Zimbabwe does not have a standing invitation, but still experts can request visits to the country. For example, we see freedom of expression requested it, but then sometimes these requests remain a bit on hold for some years. So when it comes to Zambia, they have also they have a standing invitation, but the status again, the visit needs to be negotiated, so the status keeps changing, and sometimes it remains on hold for some time. When it comes to communications, communications are the main tool, I think, that we use most of the time, that special rapporteurs rely on, and communications are usually joint. So these are formal letters that are sent to states through the permanent missions in Geneva, and they are joint communications in the sense that they are usually done by more than one expert. So it's possible for special rapporteur and human rights defenders to go ahead by yourself alone, but normally we always try to coordinate, an expert coordinate and their team coordinates, so that these then become joint communications, because the issues at stake often touch upon different topics that are relevant to different mandate holders. And it's basically, the letters are basically a summary of the facts or of the allegations received. We don't need, in terms of submissions and information, we don't need a detailed legal analysis, because if you go on the website of OECHR, and maybe I can also guide you through that a bit, you will see that everything, all the communications have very basic information with a chronology of events where you lay out the allegations, and then there is a section where you express concern, and then there is a section with the questions. So the special procedures experts can express specific concerns in relation to the allegations raised, and then ask for information. And then there is an annex, which is also a core part of a communication, an annex about international human rights law standards, and where special rapporteurs list all the relevant human rights standards in relation to the specific case raised. So this is a way also to remind states of their human rights obligations in relation to certain violations or alleged violations and abuses. The communications are only sent if we have the informed consent of the human rights defender involved. This is very important. It's not possible for a mandate holder to take up the case if there is no consent from the victims or the representative of the victim. And it's also important to highlight that what we need is really like verifiable information, detailed information, without submitting a report of 30 pages. I think what we need is really even short information, but clear and precise enough, so that this would allow us also to react quickly, because often when the information is incomplete and it's hard to verify, it takes way longer to then process the case and proceed with the communication. It's important to highlight that also the human rights defenders mandate in particular is a people-based mandate. So the communications that Special Rapporteur on Human Rights Defenders does are mostly focused on individual cases of defenders. So it's important, it's even more important in this context to have informed consent and also very accurate and to the point information. Just to give you an idea, maybe before we go to the different types of communications, in 2026 so far, the mandate of human rights defenders led or joined 154 communications, and of these, 25 were to Africa, 30 were to the Americas, 28 were to Asia Pacific, 34 were to Europe and Central Asia, 17 to Middle East and North African region, and 20 to other actors. And I'm telling you these statistics because it's interesting to see maybe some differences between region, and the lower numbers are not attributable to maybe fewer issues there, but rather to the fact that we may not receive as much information from those regions. For example, also last year in 2025, the mandate led or joined with other special procedures expert 377 communications, and of these, we see that 46 were to Africa, which is a relatively low number compared to other regions. We have 72 for the Americas, 64 for Asia Pacific, 55 for Europe and Central Asia, 39 for the Middle East and North Africa, and then the rest was to other actors. So it's also interesting because indeed, as we were highlighting at the beginning, there are some regions, some countries from which we don't receive so much information, and I think this webinar, I hope it can be useful for you also to submit more information to the mandate. When it comes to types of communications, there are three main types. One is the allegation letters that raises concern about human rights violation that have already occurred and request information about the facts. So what I've been telling you also about the structure of the communication is very much applicable to ALs. Urgent appeals are similar to ALs. The difference is that the information that is in the annex goes in the text of the communication. So the standards are reminded in the text, not in a separate annex. And urgent appeals also are different from allegation letters because they concern violations that are really time sensitive and for situations that are urgent, for example, a situation of life threatening attack or risk of deportation, ongoing violations when there is an imminent risk of death. In that case, your urgent appeals are more efficient and they can be processed faster. OLs are the other letters, and these other letters are communications focusing on law and policy specifically. So, for this, these are specific letters that don't contain allegations, and they become available much earlier compared to other communications. Allegation letters and urgent appeals become available publicly 60 days after they are sent, unless there is a reply that is received sooner from the government that the special procedures address, while the other letters remain confidential only for 48 hours. And this allows special procedures to react to problematic bills that are maybe under discussion in the parliament in that present moment. Sometimes decisions are taken very fast when a parliament is considering a bill, so it's necessary to be able to react fast. And this is also why they're published in a much quicker way. Now, I would like you maybe to try and tell me what you think would be a good way to reply to situations such as a defender is reported missing and may be at immediate risk. Do you think this should be an allegation letter, an urgent appeal, or an OL? And maybe someone, if they can read me the replies in the chat, that would be helpful.
Most people are
Yeah.
saying urgent appeals. And one person said one OL, other
Oh,
letter.
okay. Yes, indeed, it's urgent appeals because it's an immediate risk. An NGO law restricting foreign funding is before the parliament.
Everyone's saying OLs.
It is normally it should be another letter exactly. It can be an allegation letter in case there are allegations. So the difference is really that the other letter is only an analysis of the bill, while if special procedures start analyzing also the impact and there are allegations attached to it, then it becomes an allegation letter. And three, an activist was beaten by police during a protest 6 months ago.
So most people are saying AL.
Yes, exactly. So that's correct. And of course, ALs can also address more recent cases. They don't only address cases that are from 6 months before. And I want to highlight that as well because it's true that they may take time, sometimes weeks, sometimes months, depending on the capacity of the team and on the priorities. Priorities meaning like the urgent cases we receive because it's a constant. We receive a lot of information, and of course, we need to prioritize the most urgent cases where the human rights defenders are at imminent risk. But we try to not to leave, not to have such a huge backlog, even though the information we receive from across the world is really considerable. So this is the database I was telling you about. There's a link. I would suggest you go through it. You can find communications that were sent to different governments. You can also filter communications by mandate, by country, and by topic, by region, I think also. And you can also see whether there was a reply. So when it comes to reply, for example, the numbers I gave you earlier, out of the 154 communications that were sent this year, only 59 were with replies. And from last year, out of the 377 communications sent, 197 had replies. So also to highlight the fact that not always we receive a reply. I mean, it's one third more or less of cases, sometimes more. But even when we receive a reply, sometimes it's difficult to have very precise information, and sometimes states do not respond to questions with details that we wish they would give us. Um, we receive very generic replies. We receive sometimes very detailed replies. There are states that really take the time to go into the details of the case, and this is also appreciated. And we see that it's appreciated also from by the people that submitted information, because often they get more information through the replies to the communications special procedures rather than by addressing the government directly. So this is one thing that I think shows the added value of this tool and how important it is to engage with the mandate to make sure that there are such reactions to cases. And these are just some examples of how a reply can look like. And you can find them all on the website. So, as I was saying, it's a very accessible human rights mechanism. And I will tell you now how to communicate with us on submissions. You can it's a useful tool when it comes to urgent cases, because depending on capacity, also we may be able to react fast and address the government fairly quickly. The complaints may be brought against all the countries regardless of the treaty obligations. So even if they didn't ratify a certain treaty, it is still possible for special procedures to raise the cases in a certain country. And it's also not necessary, it's important to highlight, it's not necessary to exhaust all the domestic remedies, because sometimes to access mechanisms at the international level, you first need to go through various levels at the national level. And for special procedures, that is not required. You can reach out to us and address it at any time. So also in terms of accessibility, if you are the victim of a alleged human rights violation and abuse, you don't need to address us directly necessarily. You can also rely on a partner NGO that could help you, on a trusted representative. It can be lawyer, family member, it can be anyone, provided that you are involved and you are aware of the implications of submitting the case to special procedures. And it's important also to highlight that this is part of the informed consent, not that we discussed. And there can be also harm brought by these tools, unfortunately. So as Andrea was highlighting, and we were discussing at the beginning of this meeting, it's also important to be aware of potential reprisals for cooperation with the United Nations. And these things happen, unfortunately, and we have some mechanisms that monitor cases and can. There is an annual report of the Secretary General that reacts to cases of reprisals, but it's also important for you to be aware of the potential risks. And this is something that the team supporting special procedures can discuss at length with those submitting information, with the victims. We can really go into the details of what providing consent means for a communication, so that we avoid to do harm, because the do no harm principle is the main guiding principle of the work that we do. There is also, as I was saying, limited capacity sometimes to raise cases, but also to follow up on cases. So after the communication is sent, We reach out when it's published to share the link so that the source and the victim are aware that the communication has been published. But after that, after that, we ask for an update. But I think also in terms of following up, it's important that following this exchange on the update when the communication becomes public, it's important that we keep receiving information from you directly. I think it's if a case has been raised and there are developments, it's important that you keep informing the mandate about these developments, and we try to keep the information updated also on the website, which is not the OSHR website, it's a separate website, and I will show you that also later. So I want to maybe also ask you a third question. What do you think about this submission? Do you think that this would be a case of interest for the special rapporteur? And I can read it out loud. Dear Special Rapporteur, there is a woman, human rights defender in my country, who is having problems because of her work. She publicly opposed a large infrastructure project. The authorities are targeting her, and she's very worried about her safety. She works on environmental issues, and she has been intimidated several times. We believe her rights are being violated and ask you to intervene urgently. Thank you. You can just type yes or no.
People are saying no.
Okay, my next question was, is the information provided enough to take up the case? Because seeing like that, it is potentially an interesting case for the special rapporteur on human rights defenders, but also I see also depending on the violations, it can be interesting also for other special procedures mandate holders. If there are private companies involved, for example, business enterprises, it can be of interest also for business and human rights. If she works on environmental issues, it can be of interest also for the special rapporteur on environment. If she spoke out publicly, it can be of interest also for the special rapporteur on freedom of expression. So there are several experts that could be interested in a case like that, but you're right saying no when it comes to this is not enough to take up the case. We need more information. We need more details on the victims, on the alleged perpetrators, on what happened exactly, and most importantly, as we were highlighting, we need the consent. This submission per se will not allow us to take up the case, but will allow us maybe to reply and ask for more information. But this then will also require more and more time to more exchanges to be able to process the case. So if the woman human rights defender in question is at high risk and imminent risk, and we need to intervene urgently, it's better for us really to receive a very structured document with the information on allegations. And I understand that this may require capacity on your side, but it's really important for us to be able to react fast and not get back to you with too many questions. And the consent as well. Sometimes it's what slows us down in a way that it's hard to confirm consent because of certain situations that can be very, very difficult. And I think it's important maybe if you have certain issues that you identify over time and you think that special procedures can be of help in your case, it's important to maybe start thinking about the consent, the implications, how to give it. And I'm showing you now. The consent form I wanted to show you because it's important also for you to know that we don't need to disclose your name in the public database. So if you're okay sending the letter to the government, it's possible for us to then redact the name and all the identifiable information in the public version of the communication. You saw first earlier the example of the communication that I put on this PowerPoint. It's not that it's redacted only here on the PowerPoint. It's redacted also on the public database because in that case we were asked not to disclose the name. So this happens. There are some communications that are redacted, and in that case, we're extra careful also about the type of information that we publish. So you see, there are three questions, and you can fill in the form on behalf of someone else as well, in case the victim cannot sign it themselves, or you can sign it yourself. And it's important that the consent is no is it needs to be recent, so it cannot be older than 3 months. And it needs to be attached to the submission. I have consent form templates. We can maybe share also with the organizers in different languages so they can circulate it. And now we get to how to, I mean, to on what to submit. I think we already discussed it. It's important to submit consent, clear information, verifiable and precise details on the allegations. And anyone can submit information. It can be a civil society organization on behalf of someone. It can be the victim themselves. It can be family member. We receive information also from other UN colleagues sometimes that work on the ground. So if you have a UN presence where you're based, you can also rely on them, and information can get to special procedures. You can indicate in your request whether you want to address other mechanisms as well or not. And there are different ways to submit information. The most direct one is to reach out to the mandate inbox, which is here in this slide. We can also, again, I think we will be able to circulate the PowerPoint, but we can also put everything in one email so the organizers can circulate with those who registered. There is a submission platform, which you can see. There's a screenshot here. You can submit information. I think the information is available. I mean, the platform is available also in the UN languages, or maybe it's only English, French, and Spanish. I'm not sure now. But you can submit information also in different languages, and then we can try to figure it out internally how to. We have colleagues that are native speakers of different UN languages, so sometimes we also rely on colleagues from other mandates that may be able to help with the translation and identify the cases. Another way is to reach out directly to us. I'm happy to share my work UN address, but it's better to address the mandate inbox, because this is really where we receive submissions, and we check it regularly thanks to the help of our amazing Sarah, who's here with us. It's a lot of emails per every week we receive. I couldn't tell you numbers, but it's a lot of emails, and every week we consider on average, I would say, between 10 and 20 cases. So it's really a good inflow of information. There are also social media channels that special rapporteurs make use of. I cannot tell you if all the special procedures mandate holders are on social media, but you can follow the special rapporteur on human rights defenders, for example, on X, Instagram, and LinkedIn. And here we publish often reactions to cases, also individual cases, if we have, again, consent of the persons concerned to raise those cases. And this helps because it's a quick reaction, it raises visibility, and it can express solidarity in public. It's not the only public tool that special rapporteurs use. There are also PRs that are again joint PRs and are processed through our office in Geneva, and these are can be published if there is a prior engagement, which means it can mean, for example, a previous communication on a case, and then there is a follow-up with a PR. So this is also something that is possible. And in terms of tool to choose, I think it's important to highlight that we really rely also on your assessment, meaning that you will know best how is best to react to certain situations and cases. So it's important that maybe in your submission, in your email to us, you include Of course, the type of action you consent to, but also the type of action that you think can be most useful in your case. And then I was telling you we consider 10, 20 cases per week. How we do it is basically to Sarah compiles it, and then we consider them, we discuss them in a team, and the special rapporteur, Andrea, she decides what type of action she wants to take for each of these cases. So this is more or less how we operate. Other teams supporting other special procedures mandate holders may operate differently, but everyone has a generic email address, so such as like the one that I showed you here. Um, and you can find all the generic email addresses on the OACHR website under the web page of different mandate holders. So this is really the first channel. And if you do the submission through the platform that is linked here, this portal, you can also address different mandate holders by ticking boxes of the relevant mandates. So you don't only address, of course, the mandate on human rights defenders, but if you think there are cross-cutting issues when it comes to arbitrary detention, freedom of expression, freedom of assembly, enforced disappearances, can be anything really, anything like limited to the thematic and country-specific mandates. You can select all those that are relevant so that all of them will receive them. And what we do is to coordinate internally, or special rapporteurs coordinate among themselves on who can take the lead on a case. And then, of course, the communication is joint. So everyone can, and every expert can input to the communication. There are also other actions on type of support, like events, background papers, consultations, surveys, media statements, and press releases, which we discussed more or less. If you have a request for hearings, or you have an invitation to an event, you can invite the special rapporteur to attend, to speak, also by reaching out to the mandate inbox. I think this is important to highlight too, that you can easily do that. It's just one email. The impact of our work, I think this is the question that we often receive. What kind of results you see following the communications of special procedures, or like the use of other tools? I think there are different ways to contribute to an enhanced protection of human rights defenders. Of course, the protection of human rights defenders per se is the responsibility of the state, but all the special procedures tools can contribute to enhance visibility of cases, express solidarity. There are also cases in which, for example, the communication results in a release on bail, for example, or in an improved treatment in prison, or the stalling, shelving of restrictive legislation. So it's small wins, I would say, but it's still important because they contribute to a broader advocacy that is probably that in most cases is done by different organizations at the national and the international level. And it complements this type of advocacy that is done also by other organizations. So it's really, I want to highlight the importance of this collective effort between different mechanisms. And what is really important also for the mandate is to hear from human rights defenders, from the sources, from the victims, that what the mandate did. So what special rapporteurs such as Andrea are doing can really help in terms of strength that it gives, and the solidarity showed gave them like some strength and hope, and this is really important to I believe. So this we touched upon most of these points. There are the tools. We cannot provide concrete protection, but we can refer you to other organizations that have protection resources and protection mechanisms, concrete protection mechanisms. There are some resources here listed. You can find some also on the website of the Special Rapporteur, which is linked here. It's srdefenders.org. and you can write to us in case of doubt. If we receive um, request for support, what we can do, support meaning relocation, resettlement, or similar, or funding, we can refer you to these resources and organizations that may be able to help you with those types of protection mechanisms. Because unfortunately, as I was saying at the beginning, the UN cannot provide funding and cannot provide support with relocation, resettlement, and protection on the ground, physical protection even. But there are many, many good organizations that provide this support and can give you also the right tools and training to be more aware of how to protect yourself. And these organizations normally can also, we work with most of them a lot, and they can also put you in touch with the relevant mechanisms. So maybe just to conclude, last exercise, let's imagine there's this scenario. A youth human rights defender receives online death threats, is being targeted by state media, has not been arrested, and needs visibility and support. So what would be your first action in this case?
Most people are saying sí.
I would say there is no right or wrong in this case. It depends really on the personal circumstances. If there are death threats, serious death threats that are putting the human rights defender at imminent risk, it might be good to contact an emergency protection organization. In case they think a communication might be better because it seems like there's a pattern of harassment and intimidation, and they want special procedures to address with the government. This is also possible. If they prefer public advocacy because they prefer to have um, some public reaction to have visibility to their case and raise awareness and show also the general public that there is an international watchdog that is monitoring the case, then in that case it's okay to ask for a social media post. We also consider different reactions based again on your situations and your recommendations and the specificity of the different cases. A country visit, yes, maybe it's a less direct way to deal with an individual case, but during country visits, of course, we hear a lot of allegations when it comes to threats, attacks, intimidation against individuals. So these cases can be raised during a country visit and afterwards in the report and can be addressed in recommendations, but maybe it's a bit slower and less direct way to react. This is just a summary of some useful links that you can check out later when this will be circulated. And I think it's time for the questions. Thank you.